Basically, this is a pre-constitution institution.
My lord.
We will have institutions which are claiming the right under Article 30. Any institution which fulfills the requirements of Article 30 is entitled to claim a right post-constitution, irrespective of whether it has been established prior to the constitution or after that. The law is not that you can claim the right under Article 30 only if you have been established after 1950. Now we are dealing here with a pre-constitution institution. Second, an institution which is governed by a statute.
Correct.
Now, there are certain, and we are looking at the antecedent facts prior to the onset of the Constitution, prior to the adoption of the Constitution. We have to also understand that that was a period when there was absolute control which vested in the imperial power, right? Now, to what extent was this absolute power, which was yielded by the then imperial government, so destructive of any claim in regard to minority status post-constitution? So, contrary to what you are saying, we are not applying Article 50 to a situation pre-constitution. To a certain extent, you have to do that exercise. Otherwise, we will be coming to the conclusion that no pre-constitution institution can claim a constitutional right under Article 30. That's not the position. We can't say that a pre-constitution institution is not entitled to claim the right under Article 30 of the Constitution. Obviously, they are. So long as they satisfy two yardsticks, namely of being established by a minority and two, being administered by a minority. And now here, there is an issue because you're placing in issue the fact that this was really an institution which is established by the statute, according to you. That's what the preamble said.
Other options of establishment.
That they need not have gone the statutory way. According to you, they could have followed the Vishwa Bharati route. You could have, or any other institution.
I'll not surrender my rights and claim their right after.
You don't seek recognition of your degrees, in which case you could have just said, well, I'm going to be an institution which will be standing alone on my degrees, even if they're not recognized.
Stephen did
my students will not get government service, but so be it. Many other institutions did it. Stephens did it. Vishwa Bharati did it. That's one aspect of the matter. But does the fact that they really chose the statutory way, is that so destructive of their claim to minority status? Post-constitution.
Your lordships,
in which case we will be saying that once you accept the fact that you will be governed by a regulatory statute for the purpose of the conferment of degrees. It is a regulatory statute.
No, it's a substantive statute providing for substantive either power or lack of power.
But regulatory statutes are also substantive. They're not procedural.
There are three things, my lord, in this statute of 1920.
Does that completely destroy its claim of minority status?
Correct.
Or are these provisions which are designed to ensure the proper administration? Now, Governor General, let's take the case of the Governor General. You will find in a large number of institutions today, there is an approval required of a government officer, minister in charge of education. are these really, in that sense, are they controlling influences?
I
Or
have
they
understood
are
the-
there in the manner of an overall supervising influence to ensure that nothing drastic is done? We must also understand that the British government had, they had sensitivities. They didn't want any one institution in India to become so powerful so as to affect the imperial dominant power.
No, they say otherwise.
They were not running these institutions.
I'll answer that.
This was all designed to ensure ultimately that no institution went out of the mainstream as they wanted it.
No, my lord, and some movements which were started doesn't spread across the nation. That was the reason, the movement of independence, and that was
Obviously.
the reason why most of them said, no, we would
Therefore,
prefer movement and not your.
Therefore, all the regulatory statutes were intended to provide one overarching objective, and that objective was nothing should be done to destroy the hegemony of the imperial government and the colonial power. Protect the colonial power.
Maybe as a general
And
purpose.
education is a very important source of, it's a power, source of cultural power. And we have seen it pre-independence and we have seen it post-independence.
May I answer your lordship's question? Lord, first of all, the establishment is a fact which is pre-independence, which cannot be wished away even after the independence. How it was established? Number one. Number two, in my most respectful but very emphatic submission, these are not regulatory provisions. These are substantive provisions, either conferring powers or not conferring powers. Number three, when we talk of administration, Lord, we never talk of administration in air. Administration is always a layered exercise. For example, my lords, administration of a court, let's say for a particular high court, there would be 5 registrar generals, registrars having different powers. They would be administering, but according to what? According to something which is decided by some higher authority. That higher authority would not be doing on day-to-day basis the administration. Thereafter, the administration would percolate. But ultimately, the controlling thing would be the statutes. Controlling thing would be, in case of a high court, the resolutions, the constitution, etc., passed by the competent authority who has the ultimate control. So, my lord, please, my lord, do not take these as mere regulatory provisions. These are substantive provisions. Either we confer these rights A, B, C, D. You are not supposed to do X, Y, Z. It's very clear. These are power conferring substantive provisions under the 1920 Act, not just regulating who will administer. They are not, my lord. Therefore, my lord, please see, my lord, page 4. Please see page 4, my lord. And establishment is a factum, whether I succeed or we succeed or other side succeeds. Establishment is a factum which has taken place in 1920. That cannot be wished away. What the British did may have been completely wrong, but it has happened, and majority of the institutions have chosen to ensure that that does not happen with them. They came after the constitution and said that now make us a university or deemed to be the university because we established ourselves. We established this institution. And we have maintained its independence. We are administering it without any outside interference. In this context, please see page 4, Lord, section 28. J, Lord, ground J. Both the ordinances and the statutes, Lord, these are the administrative governance documents. A will have some powers, B will have some powers, C will have some powers, and Pune will have some duties. Powers coupled with duty for everyone. That would be decided by ordinances and by the statutes. Correct, my lord? That's the administrative structure substantially provided as a substantive provision in the Act. Statute could not have been amended without approval of the Governor General in Council. The power in this regard was so wide that the Governor General in Council could reject the amendments proposed by the authority of the authorities of the university. The relevant provision are section 28(2)(c) and 33. Lord, please read this. No new statute means after the first statute which were made by the Imperial Council, no new statute or amendment or repeal of an existing statute shall have any validity until it has been submitted through the visiting board, completely non-Muslim visiting board, which may record its opinion thereon to the Governor General in Council, and mark this word, my lord, and has been approved by the latter, who may sanction, disallow, or remit it for further consideration. It never was.
Yes, Mr.
Please. So the governance document, that registrar will do this, deputy registrar will do this, joint registrar will do this, court master will do this. I'm just giving a hypothetical example. And peon will do this. That is the document, that governance document, which is the documents of administration. There is no power in the court, exclusive power with the court. The Governor General in Council would say that no, this is not acceptable. Similar is the position with ordinance. No new ordinance or amendment or repeal of an existing ordinance shall have any validity until it has been submitted to the court and the visiting board, which may record its opinion to the Governor General in Council and has obtained the approval of the latter, who may sanction, disallow, or remit it for further consideration. Well, the respectful submission is, as on 1920, it was neither established nor was being administered by the minority, and therefore their claim post-constitution would not sustain. Lord, I can say Mao, if would have remained Mao College, could have raised the claim after the constitution.
Suddenly said Mao, I said, where does Mao come from?
No. MAO, my lord, I'm sorry, not
Yes.
not Mao Zedong. No, I'm sorry, my lord. Mohammedan Anglo
Yes.
Oriental College.
In a lighter sense.
Your lordships are right. That college could have raised, not could have, it could definitely have raised that we established it. We were administering it. We are a minority now post-constitution. Because before that constitution, there was no minority concepts. There were, all of us were subjects, Hindus, Muslims, Parsis, Sikhs, Jains, everyone. Now, we have been doing it. That's what, my lord, the St. Stephen did. St. Stephen did that, my lord. And
right, now we have seen this note on
now
administration.
please
What
see,
is the next point?
Post-constitution, my lord, I have given the chart.
Which is that chart?
Lord, page 5. Page 5. Post-constitution, after taking into consideration all amendments, Lord, as it stands today, as AMU stands today, is there any administrative control? Because your lordships, it is not disputed that word "and" will have to be read as "and" only. Established and administered, not "or." It's not their argument also. Now, Lord Chancellor need not be a Muslim under the new act. De facto governor appoints him doesn't make the legal difference. Lord, kindly see, my Lord, if
How many chancellors have been non-Muslims actually in the case of the institution?
we have not examined, my Lord, but possibly all were Muslims. That's the convention. I am on law. 23 or 25 so far. So, my Lord, de facto status would not change the legal position. My Lord, for example, Lord, suppose there had never been a lady attorney general. That doesn't mean that it has to be a man. It incidentally happened to be a man.
That argument may be slightly different. That argument.
But I'm giving the example may be different.
That would be a correct argument.
Lord, example may be a different, my Lord, example,
but when we are examining whether what has been the history in the past, whether administration can be only judged on the basis of what has happened and what has been actually after in last, how many, 1920 till we almost now going to be completing 100 years in another 3 years?
103 years, yes.
103
Lord,
years.
I just answer that question.
Any time in the past where the chancellor, pro-vice chancellor, vice chancellor have been non-Muslims?
Lord, I'll check up and say, but not to my knowledge. Possibly they were Muslims.
And why is it then that governments, both before the advent of the
Lord, I'm told
constitution,
4 were non-Muslims, my Lord. 4 were non-Muslims.
but why is it that before the advent of the constitution and post the constitution, the predominant choice of chancellors by successive governments has been of Muslim? That's certainly one factor which has to be borne in mind.
Lord, can by government appointing a particular community, though the law does not require it to do, change the character of that university, my Lord? That the government keep on appointing Muslims. Irrespective of Article 30, it's not established or administered.
As you rightly said, that we have to look at it in a holistic perspective.
Yes.
Could it possibly be a recognition of the fact by successive governments that this is how they have been perceived at an administrative level
Well, then
by
they
the
would,
university itself?
then they would not have required 81 amendment. If that was the interpretation, that is how it was being given, I'll come to, my Lord, the periodical interpretation. Why I say, my Lord, it need not be a Muslim, there is a reason. Your lordships have seen the provision of court, where there was a provision that all members shall have to be Muslim. That's the legal provision your lordship would bear in mind. Here it doesn't say the chancellor will have to be Muslim. Incidentally, he was a Muslim, he or she is different thing. That would not change your lordship's, my Lord, adjudication whether this has a minority status or not.
There's one more thing. Suppose, let's assume it's a minority institution.
Yes.
In a case. The minority institution appoints a non-minority as the vice chancellor or chancellor. Will it make it non-minority?
It cannot. My Lord, St. Stephens, reverse, your lordships are right. St. Stephens do not always appoint, my Lord, principal from the Christian community.
Fairly speaking, therefore, when we look at the term administration, we have to take into account how actually it is administered on the ground.
The legal position, not de facto position. The legal position. My Lord, in case of St. Stephens, my Lord, it is never that only Christians were appointed as principals. Then it's bad. That's not the concept of a minority institution. But Lord, my point is, your lordships will go by the statutory provisions.
because our law recognizes the power of the minority to appoint the head of the institution. No outsider can be foisted. You may choose somebody else. You may have a distinguished nuclear scientist who's not a minority. But
Ideally
that's a
not.
choice.
I'm
The element is
not
not.
saying
The
legally
element
wrong.
is the choice.
I'm not saying legally wrong. You should not confine the benefit going to the students to one community. There may be many other eminent people, may not be belonging to a particular community, who can take the institute to a further height. But you can't deprive the students of that. That's what as an ideal position, not legally, it is wrong.
Okay. Article 30 in the end uses the word choice. If by choice a minority institution agrees to abide by certain terms and conditions in order to establish itself and get certain, say, a degree, will they lose that by choice if they do it? Will they lose their minority status?
It is a minority,
It is a minority institution.
undisputed minority.
Yes. By choice, they agree to certain rules and regulations and even administrative overall supervisory control. Will they lose their minority status?
Not after the constitution. If it is established after the constitution, no. My lord, for example, take a flip side.
Why should
Take a
that-
flip side, my lord.
Once you accept that, then why not before the constitution?
My lord. My lord,
Because once you accept, then the administration
Take
is
a-
with them.
my lord, take a flip side of it. My lord, suppose in Banaras Hindu University, as a tradition of a gesture of goodwill, the government continued, my lord, had continued. I'm giving a hypothetical example. Only Muslims are vice chancellors and Muslims in the position of power. Would it come, and I'm posing a question to myself, would it convert itself into a minority institution, my lord? If what example, my lord, we are discussing is true, the reverse also has to be true. If de facto can change the de jure position, then, my lord, it should apply to everyone. And, my lord, there are some benefits to a minority institution. From tomorrow onwards, my lord, some institution can start converting itself into a minority by merely appointing people. Though law does not require, the statute incorporating it may not require. All British, my understanding is right, all British authorities were Christians in those days. So, my lord, de facto, what is the position is, in my respectful submission, irrelevant. It may be a practice, it may be a political stand of the government, it may be, my lord, for various reasons, as the, my lord, in the initial Britishers also were requested that please, izzat ke liye, but that's the word which is used. Take into account our feelings and have Muslims. Maybe that's the reason. But that doesn't define the character of the institution. But therefore, I say the way court mandates only consisting of Muslims with the provision
Let's
now.
quickly run through this chart so that we can go on to the next.
Here, my lord, when I say need not be Muslim means the law doesn't require him to be Muslim. He may be Muslim, he may be any other religion. Chancellor need not be Muslim, pro-chancellor need not be Muslim. My lord, throughout, I'm not reading it, up to proctor need not be Muslim. Then representatives of the department and colleges need not be Muslim. Some expert, my lord, in a chemical engineering branch may be sent as a member, my lord. He may not be Muslim. He may happen to be a Muslim. But the law doesn't say that a representative of department of colleges belonging to Muslim community. That's not the law. Need, therefore, my lord, I am carefully using the word need not be Muslim.
Okay, this, the chart in Annexure A is pre-1981 or post-1981?
As on date, as it stands.
And what is the position pre-81?
My lord, I have said, my lord, court is concerned, it was full Muslims. Till 51 amendment, it was deleted. 1951 amendment, which was deleted. I'll show, my lord, that comparative.
So this is as it exists
As
today.
it exists today. And as it exists today, my lord, if your lordships were to go, need not be Muslim. My lord, when I say, my lord, representative.
There may be a slight problem in this because we have to deal with the whether it's an institution which was minority or not, as on the date when the constitution.
Correct. This is irrelevant according to my submission.
So this 1981 amendment may not be so much, or post 1981
Yes.
may not be so much, because if it was a minor, you can, to that extent, there is no list between the two sides. If it was a minority institution as on the date in 1950, then it will continue to be a minority institution.
Not the difficult.
Because they have challenged, some of them have challenged the 1981 amendment also.
Yes, that's the issue, bro. That I'll come to that, my lord. And there, when the bill was introduced, it was introduced on the ground that Congress had that in the election manifesto. That was the ground. And there is a beautiful opposition by an eminent parliamentarian who was an eminent counsel of this court, Somnath Chetterjee, that you can't do this. This is not the way you take away basis of the judgment. I'll come to that. But my lord, there are only 35 persons who can be Muslims out of 189 as on date. Who can be Muslims, my lord, I am saying. Mandate, no mandate that they have to be Muslims. For example, my lord, representatives of alumni, past alumni. But there are all community students who are studying here. They have engineering college, management college, medical college, everything. Maybe other community people may represent that constituency of alumni. Two persons representing Urdu language, my lord, for example. He may not be a Muslim, my lord, but an expert in Urdu. There are people who are experts in Urdu. They can, my lord, be the representatives. So therefore, I carefully use the word need not be Muslim. The law doesn't require them to be Muslim. But 39, 35 people, 37 people may be Muslim. I am against, they also don't require Muslim. Please, my lord, come to page, my lord, page 8.
What is the reason to bring in representatives of Muslim culture and learning?
My lord, there is one of the subjects. The way, my lord, other subjects are taught.
Why do they at all have to bring in people who are representatives of Muslim
There is a
culture
small
and learning?
carve-out.
Or what is the need to bring in, say, representatives of the All India Muslim Education Conference? What is the genesis of that?
My lord, just, my lord, if your lordship sees, there are several subjects being taught. Lord, there is, my lord, a separate constituency, representatives of teachers other than chairman and department and principals of colleges. So they have representation. Chemistry will have a representation, medicine, biology, etc., etc. But one of the, my lord, subjects out of several is Muslim theology and Muslim culture. Therefore, they have representation. But therefore, it does not say, the provision does not say they will be Muslims. Muslim Cultural Association will send 5 people. They may be Muslims. They may send others also. So therefore, I say what is required as per Kerala Education Bill is sprinkling of outsiders. This is not sprinkling of outsiders. This is predominant outsiders. If I may use that expression, nobody is an outsider, but predominant non-minority people. I'll now, my lord, come to, my lord, I'll just show the chart, my lord. My lord, the Chief Justice also, my lord, desired that there has to be on one page how the amendment took place. My lord, first in 51, 65, 72, 81. So we have prepared that chart. It won't take more than 5 minutes because we have depicted the amendment in different colors. So your lordship would get only in 5-7 minutes. My lord. The amendments.
Section 9 was amended in 51 or 59?
Pardon?
Section 9, that
50.
amendment, 51.
50. My lord, your lordships may see the legend on the top. Black is original act, my lord, as it stood. I'm sorry. But what is in black is as it stood when the act was passed. Red is 51 amendment, orange is 65 amendment, gold is 1972 amendment, and green is 81 amendment.
All right.
Lord, the relevant would be, my lord, kindly see the green one, my lord, first in 1981. an act to establish and incorporate a teaching, established and is deleted. My lord, with limited experience, my lord, I have come to know about such an amendment for the first time, where the preamble is amended, that it was not established. The historical fact is changed by making an amendment after about 60 years. And incorporation continues. So incorporation is also establishment. They possibly forgot, my lord, that established and incorporated. Now, please, my lord, see,
No,
rest of the,
there may be an alternate reading also, which is that the amendment to the preamble is to bring the preamble in conformity with a historical fact. And in that sense, it is
historical
declarative.
fact, my lord, cannot be changed, my lord, by.
They're not changing a historical fact. They're changing the provision of an act which was inconsistent with the historical fact. So as to bring it in conformity with the historical fact. I mean, there's an alternate reading possible.
My lord, kindly appreciate.
One more thing. This is the amendment by the parliament.
Correct.
And is the government accepting the amendment or?
I'm not.
How can you not accept it, accept an amendment by parliament? Mr. Solicitor, parliament is an eternal, indestructible body under the Indian Union.
Correct, my lord, and
And
continuing.
irrespective of which government represents the cause of the Union of
No,
India.
I'm not saying.
Parliament's cause is eternal, indivisible, and indestructible. And we can't hear the government of India to say that an amendment which Parliament made is something I don't stand by. You have to stand by this amendment.
Allow me to answer that, my lord.
You have an option. You go
Allow
through
me
the
to
amending.
answer.
You have an option. Go through the amending route and change the amending act
Allow me
again.
to answer that
That's
question.
ultimate power.
My lord, allow me to answer that question. My lord, I am not arguing a matter of A versus B. I am before a 7-judge constitution bench answering constitutional questions. That is number one. Number two, the amendment in question was subjected to challenge before the High Court, and there is a judgment declaring that it is unconstitutional for ABCD grounds. And as a law officer, it is my right as well as my lord, entitlement and duty to say that this view appears to be correct. And third,
Mr. Solicitor, this will be radical, because a law officer will be then telling us that I don't abide by what Parliament has done.
my lord, in that case,
You have to stand by what Parliament has done, but Parliament is supreme. Parliament is undoubtedly supreme in its lawmaking function. Parliament can always amend a statute. In which case, the law officer can say, well, I have an amended statute now, which I am going to place
your
before you.
lordships expect.
Can we hear any organ of the union government to say that notwithstanding a parliamentary amendment, I don't accept this amendment?
Lord, I am supporting the judgment. Lord, would your lordships, my
In
lord,
that sense, Parliament.
please allow me to answer this.
That's why I said, Parliament is an eternal, indivisible, and an indestructible entity under the democracy.
No, I am not disputing that, but my lord, would you? I'm posing a question to myself.
How can you
Would
say
I-
that, look, I don't accept the validity of an amendment?
Hmm?
Or I don't
Lord,
accept, I
during
don't accept that there was a ground for
Can
this
I
amendment.
answer? Yeah, it's more, my lord, one-sided therefore, my lord. Can I answer that? Would a law officer be expected to say that whatever amendments were made in the Constitution of India during emergency were true only because they were made by the Parliament? Here, I have a judgment of the Supreme.
But Mr.
Allow me
Solicitor,
to complete.
that's why the 44th
I
amendment
will not
came
raise
in.
that point, my lord.
That's why the 44th amendment.
Let others
came in.
argue, my lord. If that is so, my lord, I will not raise that.
If the 44th
I-
amendment
Lord,
came in only for that. The 44th amendment came to redress the evils which were perpetrated in the name of a constitutional
Who will
amendment.
decide, my lord, that these are evils being perpetrated?
Obviously, exactly. You prove my point. The power to decide that is in the elected body of the people, which is Parliament.
My lord, there is
Parliament can always say that what we did during the emergency was wrong, and we are rectifying it by the 44th
not
amendment.
after it is set aside by the division bench of a high court, my lord, and therefore it is not on the statute book. And when I am not in A versus B situation, I am in a constitution bench answering a legal proposition, whether such a thing can be done or not. And if I do not do, and there is an affidavit filed by the government, it's not my stand, it could have been my stand also. But if I cannot argue, my lord, that this amendment could not have been made, I will have to support, any law officer will have to support every amendment made during emergency, irrespective of, my lord, whether it is my view or anybody else's view that this was to remove some anomalies or some bad things happening to the citizens of India. I'm sorry, please don't make it a political thing. Please don't do this. Then don't interrupt. Then don't do it. Then don't. You said don't. I don't want to interrupt, and then you interrupt.
Ability in court, please.
My lord, I'm sorry, my lord. Your lordships would come in. Your lordships would come in.
Let's not,
Argument.
Your lordships would come in, my lord.
Let's 1 second.
No, my lord.
One
Here,
second. 1 second, Mr. Let's not allow the pristine character of the dialogue to degenerate.
I'm
1
yes, my
second.
lord. This is
All right. We'll give you
unacceptable.
1 second. We give you 30 seconds to make a point of law, not on personally on the Solicitor General. Let's keep out personal, yes, just 30 seconds.
I was in court on the day when the emergency argument was, I was only going to make a historical reference, Mullah. I was sitting in court when the Attorney General of India, Nirande, was standing here and arguing that what has been done is right. I defend the emergency provision. Why? Because he could not say otherwise. It's only that I'm saying. But I was not going to say anything against him.
Yes.
I don't know why, but
No, my lord, you did say something. You used an uncivilized word which is not used in the court, and you generally do not use, maybe infected as of now. But, my lord, I'll say, your lordship, the distinction is, Nirende was not, my lord, in a situation where one high court had struck it down and the provision was not on the statute book.
yes, the
Here-
Madhya Pradesh High Court had struck it down.
9 high courts.
Yes. What do you?
There were other high courts which have upheld, and there is all your lordships are aware, Mr. Nirende told the court that if somebody is hanged, can we not do anything? Yes, he said, yes, we cannot do anything. It was not to defend it. It was to instigate the judges that please interfere. This is the position. Lord, everyone knows, my lord, there are two versions. When Mr. Nirende, the learned Attorney General, then told the court, when the court asked, do we not protect Article 21 if somebody is being hanged or his personal liberty is deprived? He said, yes, you cannot do it. It was not to defend the act. It was to instigate the court that this is the position. Please interfere.
Mr. Solicitor General, let's come back to the point. Your
Yes.
argument is that 1981 amendment, you need not to comment for the simple reason that by virtue of a judicial verdict, this provision has been erased from the statute book.
Correct.
That is what you want.
It
we can
doesn't
now-
exist as of now. I leave it at that, my lord. I will not, my lord, be uncivilized in my lord, arguments. Now, my lord, please come to Mr. Sibal is generally not, my lord, but my lord, please see, my lord, 51 amendment first. My lord, 51 amendment is at page, my lord, section 8. My lord, please see section 8. It is made, my lord, this is post-constitution. The university shall, subject to the provision of this act and the ordinances, be
Section
open.
8. Section 8.
8. Read is 51 amendment, my lord. The university shall, subject to the provision of this act and the ordinances, be open to persons of either sex and whatever race, creed, caste or class, and it shall not be lawful for the university to adopt or impose on any person any test whatsoever of religious belief or profession in order to entitle him to be admitted therein as a teacher or student, or to hold any office therein, or to graduate thereat, or to enjoy or exercise any privilege thereof, except in respect of any particular benefaction accepted by the university, where such test is made a condition thereof by any testamentary or other so and so, so and so. Now, my lord, please see.
Provided that nothing in this section shall be deemed to prevent a religious instruction being given in a manner prescribed.
Yes, my lord.
By the
To prevent
ordinance.
religious instruction being given in the manner prescribed by the ordinances to those who have consented. My lord, this is 28.
Yes.
Article 20.
Just now, and now come to 28, Article 28. Just have a look.
28, my lord, yes.
23.
But, my lord, I must tell your lordships, this is not under challenge now. But this was, I'm just saying, this was to bring it in conformity with the Constitution.
Just let's have a look at 28.
28, my lord. No religious instruction shall be provided. No religious instruction shall be provided in any educational institution wholly maintained out of the state funds.
Now, in 1951, this was a religious, this institution was maintained by, wholly by state funds?
May not be done, may not be wholly.
No, wholly we'll have to exclude small little fees, etc. But it was,
Otherwise, yes.
it was
Ye-
wholly.
Yes.
Yes, in fact, it is your argument that
Yes,
it was
yes.
wholly.
They were having some minor.
So there is a bar on providing religious instructions in institutions wholly maintained by state fund. Now, the
Correct.
two.
Nothing in clause 1 shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution.
So the exception carved out is
Yes, this
where
is,
it is administered by the state, but the establishment is by the religious institute. It's a trust or endowment which is established there. The religious instruction can be given.
Yes.
Now read 3.
no person attending any educational institution recognized by the state or receiving aid out of the state funds shall be required to take part in any religious instruction that may be imparted in such institution or to attend any religious worship that may be conducted in such institution or in any premises attached thereto, unless such person or if such person is a minor, his guardian has given his consent thereto.
Okay. According to you, as on the date when Constitution was enforced, which part of Article 28 will apply? Which clause of Article 28 will apply?
Note 3.
Not 1 and 2?
1 and 3. 2 may not apply, 1 and 3.
1 applies, then is it possible for that institution to grant or permit religious instructions?
One is absolute, my lord, that's what your lordship said. It may not be permissible, my lord. As the constitution reads, my lord, it may not be permissible. But, my lord, possibly
Then when we, the 1951 amendment, which is is in terms of 3. To give an option, when you say 3 applies, indirectly you are accepting it as a minority institution. Because 3 only applies to minority institutions.
no, my lord.
Yes. Now, not, sorry, it applies to non-state funded, only non-state funded.
Yes.
You're right to that.
Yes, sir. So, my lord, but in any case, this is not.
Or in case of state funded institutions, which are minority institutions, 3 obviously will apply.
Now, my lord, section 9 was deleted, my lord, if your lordship sees, my lord. Section 9, my lord, which required, please see, my lord, 9, original act. The court shall have power to make statutes providing. I'm
Let's
sorry.
go back to Article 28 and the proviso to section 8.
I'm sorry, my lord, I was little taken.
We'll just go back to the proviso.
No, I was on the last point, my lord. My apologies, my lord. But I genuinely feel I can and I will.
Sorry?
81. The 81 amendment, my lord. My apologies for that.
No, the 81 amendment, let's see section 8 for a moment. We were looking at section 8 at your, on
Yes.
that page.
As it stood, Manoj?
No, after the 81 amendment, because the 81 amendment is in red.
51 is in red.
Sorry, I'm sorry. I'm sorry. I meant the 51 amendment. The 51 amendment is in red.
Correct.
Now, what the 51 amendment does is introduces the proviso, provided that nothing in this section shall be deemed to prevent religious instruction being given in the manner prescribed by the ordinances to those who have consented to receive it.
Correct.
It expressly allows for religious instruction in AMU, subject to the consent of those who are receiving religious instruction. Now, under what provision of Article 28 does this proviso to Section 8 fall? If you look at the first clause of Article 28, the first clause of Article 28 interposes a complete bar, right? See Article 28(1).
No religious instruction shall be provided in any educational institution wholly maintained out of the state funds.
No, it is maintained out of state funds. For a moment, we'll take it on the basis that it is wholly maintained out of
Correct,
state
Manoj.
funds. So, any form of religious instruction would ex facie be barred in AMU by virtue of the provisions of Article 28(1). Now, Article 28(2), Clause 2 lifts the bar to a certain extent.
Except
Right.
for two exceptions.
Right.
Yes.
Now, where does it lift the bar? Let's read 28(2). Nothing in Clause 1 shall apply to.
I'll read. Your Lordship, shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution.
And now what does 3 do? That no person who attends such an institution, a state-aided institution, will be compelled to undergo religious instruction unless the parent or guardian has consented. This puts the requirement of consent. So Clause 2, then otherwise there would have been an absolute bar under Article 28(1). What Clause 2 of Article 28 does is to lift the bar. In the case of an institution which may be otherwise administered by the state, but which has been established under an endowment or trust which requires that religious instruction shall be imparted in such institution. So,
two doesn't apply in fact.
Proviso, perhaps the proviso to Section 8 is in recognition of, is in implementation of the provisions, or is pursuant to the provisions of Clause 2 of Article 28. But for Clause 2 of Article 28, that proviso would have run afoul of Clause 1 of Article 28. So that proviso comes in as a result of Clause 2 of Article 28. Now, when it comes under Clause 2 of 28, it's in recognition of the fact that this is established by a trust or endowment, which requires that religious instruction has to be given or imparted in such institution.
So the government
may be
is
the position.
kind of bound by the covenants of that trust or endowment.
Or trust.
Yes. Another thing. Two has no relevance. It's a different fact. NPA. My respectful submission is that even if there is some some internal generation of money, possibly one may not apply, but that situation we are not facing. Here it would be 3. That is why Section 9 is deleted. Number 1. Number 2, 28 is
So
agnostic.
what it permits is, what the 51 amendment permits is, you can impart religious instructions in this institution.
Yes. And,
In
my lord, important.
education in this institution. So indirectly, they are saying that one will not apply. Now, one may not apply if the institution falls under Article 30.
No, not necessarily.
We'll have to harmoniously interpret Article 28 and Article 30.
May I, my lord, answer that question, my lord? Lord, may I give one more? Hmm.
Yes. We will. We will.
Lordships can, my lord, at this stage examine. 28 is an agnostic provision. It applies to minority as well as non-minorities.
Correct?
So even if it is a minority institution or non-minority institution, one says if it is wholly,
It introduces the character of secularism in education.
yes, and three kinds of take a middle path. That all right, if you wish to, you provide, but don't compel. And even in case of a minority, academically and constitutionally, it is possible that a minority institution, say the Muslim minority institution, may say that we will provide religious education both in Hindu studies and Islamic studies. What they cannot do, they cannot compel the students. So it is, the
Three is a provision which is against compulsion. What 3 does is basically to create an option. That's why 9 came to be deleted, really speaking in that sense.
Exactly, I'm obliged.
9 was deleted. Because
Simultaneously.
9 provided for compulsory religious instruction to Muslim students.
Yes, therefore.
Now, after the deletion of 9, it's not that religious instruction is done away with, but all students, Muslim or otherwise, have now a choice.
There may be therefore an exception to both 1 and 2. Read it carefully.
Another very important aspect of 3 is 3 applies even if you are not wholly maintained out of state funds. Because 3 merely says receiving aid. Receiving aid may be 5%, 10%, whatever. Once you are receiving any aid, then 3 applies. 1 applies, 1 is wholly out of state funds.
So, meaning thereby, if you have a madrasa or a gurukul, for both, I'm saying, without receiving any aid, you impart religious education, not the religious instruction, no difficulty. But the moment you start accepting something from the government, constitution steps in, and whether...
This will be important. Just read 3 once again.
Yes, Madam. No person attending any educational institution recognized by the state.
So 1 requirement is recognized by the state. Number 2 is...
Or receiving aid out of the state fund.
Now here, the words are not used wholly funded by the state.
Correct, Madam. Yes.
Any aid received by the state.
Not wholly.
If not wholly. So if we read it as an exception to 1, then it may be permissible even for wholly funded state institutions to impart religious education.
Not wholly.
You're not accepting that position. Your position is if it's wholly funded by the state, then number 1 apply, clause 1 will apply. Be careful what you're saying, it may have repercussions.
Actually, clause 1 imposes an absolute bar. Right?
Correct.
That if you are funded wholly out of state funds, you cannot have a religious instruction at all. That's clause 1. Clause 2 lifts the bar, which is evident from the use of the words nothing in clause 1.
It's an exception to 1.
It's an exception to 1. Now, what 3 does is 3 imposes a requirement when you are receiving any aid, or of course recognition. You're not in the recognition aspect right now. So 3 is conditioned if you are receiving any aid, even if you are receiving 5% aid or 1% aid from the state, 3 applies. And what does 3 say? 3 says is that you can have religious instruction, but you can't make it compulsory unless, in the case of a minor, the parents or the guardian consent. Therefore, 3 in that sense, 1 applies only where you are wholly funded by the state. Even if you are not wholly funded by the state, you cannot compulsorily have religious instruction, which therefore means that if you are not funded by the state, you can make religious instruction compulsory. There's no difficulty. If you are funded by the state, whether wholly or in part, at the least, if you are funded in part, you are receiving any aid, because it says receiving aid. If you are receiving aid, you cannot have compulsory religious instruction. That's the purport of it.
That's the middle of the way. Then if somebody wants,
but if you are wholly funded by the state, you cannot have any religious instruction at all. That
even with consent. Even with consent.
Even with consent.
Is that understand?
Even if you are not receiving, but if you are a recognized institution,
and
you cannot come.
And recognized. So if it's either way. If you are recognized but you are not receiving aid from the state, you cannot have compulsory religious instruction.
No, but therefore, if we accept your position, if it's a non-minority institution, can they impart religious education?
So, yes, subject to 28(3).
But then 28(3), as per the stand taken by you, will only apply to non-fully funded institutions.
So a non-minority institution which does not receive any aid, You can have compulsory religious instruction.
Yes, no, no, like you.
But even if you're a non-minority institution and you're receiving any aid from the state, you can't have compulsory religious instruction.
Correct, Manoj. And
So
therefore, 9 is
28 applies. 28 is agnostic to whether you belong to the minority or otherwise.
correct.
28 applies
No,
across.
that's what TMFI also recognizes.
Minority or non-minority.
As Brother Suryakant says, 28 draws no distinction between whether you are a minority or non-minority.
No, that's what I say. 28 is agnostic provision, whether you are minority or non-minority. It is
Also because 28 occurs in a subtitle or subpart
Exactly,
called
Manoj.
right to freedom of religion.
Yes,
that
Manoj.
applies to everybody.
29 and 30 only talks of
Cultural
minority.
Cultural and educational rights.
Yes. And 29 and 30 only uses the word minorities.
Institution and
I can always support.
other people.
Necessary for the reason that 51 amendment is not under challenge.
No, we are interpreting.
Yes.
We are just interpreting. We are not going into the merits or demerits of 51
Yes.
amendment, but the impact thereof. You see, if we accept this argument,
Well,
then it
therefore,
will be a minority institution which is fully funded by the state cannot impart religious education.
correct. And
And in spite
once,
of Article 30, Clause 1.
my lord, once section 9 is deleted, compulsory education in to Muslim students, well, whatever limited minority status was there, that also went in 51. Compulsory education,
On Article Clause 1 and 3 of Article 30, 28.
no, TMFI, my lord, I'll just read.
Does it deal with that issue? Question.
Yes, my lord, kindly see, my lord, page. This is 5A, para 144, page 651, my lord. 651.
Not there in this document.
So there, the context was little different, but 28 is discussed. But my respectful submission would be in facts of this case,
Has this legal position been interpreted? The Article 28 been interpreted?
yes. Yes. Lord, please see page 140, para 144, my lords have. Lord, page, volume 5A, page 651. The discussion in 11 judge bench judgment of TMFI about 28. My Lord Justice Mishra and Justice Padiwala. May I read, my Lord, para 144. It cannot be argued that no conditions can be imposed while giving aid to a minority institution, whether it is an institution run, this is post-constitution,
What page number?
651. Please kindly bear in mind, this is post-constitutional scenario.
Yeah.
The earlier conditions can be imposed. The Britishers were not bound by 30 or any other fundamental thing. It cannot be argued that no conditions can be imposed while giving aid to a minority institution, whether it is an institution run by the majority or the minority. All conditions that have relevance to the proper utilization of the grant in aid by an educational institution can be imposed. All that Article 30, Subarticle 2 states is that on the ground that an institution is under the management of a minority, whether based on religion or language, grant of aid to that educational institution cannot be discriminated against if other educational institutions are entitled to receive the aid. That's Article 14, my lord. The condition for grant or non-grant of aid to educational institutions have to be uniformly applied, whether it is a majority-run institution or a minority-run institution. As in case of a majority-run institution, the moment a minority institution obtains a grant of aid, Article 28 of the Constitution comes into play. When an educational institution is maintained out of state funds, no religious instruction can be provided therein. Article 28(1) does not state that it applies only to educational institutions that are not established or maintained by religious or linguistic minorities. Furthermore, upon the receipt of aid, the provisions of Article 28(3) would apply to all educational institutions, whether run by minorities or non-minorities. As
So really speaking, right, and therefore the court says that 28 applies both to minority and non-minority institutions. 28 applies to both.
Provision, because we are right now we are in the mental framework of religious
28,
minority.
once you receive aid or you are recognized within the meaning of 28(3), then the provisions 28(1) applies once you are wholly funded by the state.
We are,
And 28(3) applies whether you are receiving part aid or full aid or whether you are recognized. Then 28(3) the bar comes in that you cannot compel religious instruction. That's the. And it is not as if 30 overrides 28. The prescription in 28 applies to a minority institution as well.
as well. Lord, kindly.
Says the same.
Yes.
Page number?
TMA
Page number?
5.
Which page number?
This page
What is the page number?
550.
This is 5626.
626.
626.
626. And that would while Article 28(1) and 28(2) relate to your lordship's got that. While Article 28(1) and Article 28(2) relate to institutions that are wholly maintained out of the state funds, Article 28(3) deals with an educational institution that is recognized by the state or receives aid out of the state funds. Article 28(3) gives the person attending any educational institution the right not to take part in any religious instruction, which may be imparted by an institution recognized by the state or receiving aid from the state. Such a person also has the right not to attend any religious worship that may be conducted in such institution or in any premises attached thereto, unless such a person is, or if he or she is a minor, his or her guardian has given his or her consent. The reading of Article 28(3) clearly shows that no person attending an educational institution can be required to take part in any religious instruction or any religious worship unless the person or his or her guardian has given his or her consent thereto. In a case where the educational institution has been recognized by the state or receives the aid out of the state funds. We have seen that Article 26A gives the religious denomination right to establish an educational institution, the religious denomination being either of the majority community or minority community. In any institution, whether established by the majority or a minority religion, if religious instruction is imparted, no student can be compelled to take part in the said religious instruction or in any religious worship. An individual has the absolute right not to be compelled to take part in any religious instruction or worship. Article 28(3) thereby recognizes the right of an individual to practice or profess his own religion. In other words, in matters relating to religious instruction or worship, there can be no compulsion where the educational institution is either recognized by the state or receives aid from it. Article 29 and 30 are a group of articles relating to cultural and educational rights. Article 29(1) gives the right to any citizen of a section of citizens residing in India or any part thereof and having distinct language, script, or culture of its own to conserve the same. Article 29(1) does not refer to any religion, even though the marginal note of the article mentions the interest of minorities. Article 29(1), it can be linguistic. 29(1) essentially refers to sections of citizens who have a distinct language, script, or culture, even though their religion may not be the same. The common thread that runs through Article 29(1) is language, script, or culture and not religion. For example, if any part of the country, there is a section of the society that has a distinct language, they are entitled, even though the persons having that language may profess different religions. Article 29(1) gives the right to all sections of citizens, whether they are in minority or majority religion, to conserve their language, script, or culture, etc. But I may read further. For example, Gujarati being a linguistic minority in say Delhi, may provide for an institution, and it may have people from Muslim community, Hindu community, Parsi community, all speaking Gujarati language. So what is binding is the linguistic minority character or some kind of a culture. That's what 29 provides.
But Parsi Gujarati is very different from Gujarati Gujarati.
That is true. That is true.
A little more colorful also.
Sometimes extra colorful. The Parsi abuse doesn't feel like an abuse. They abuse it in such a way, my lord, that lovingly. Your lordship knows, my lord, my lords have the experience.
Abuse lovingly.
What?
I said Gujarati notes.
I don't bring, my lord.
No, but,
I am not a man in anyway, my lord. I am, my lord, just.
Time two may also be there. It's important.
29(2).
No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of the state funds on grounds only of religion, race, caste, language, or any of.
So we have now examined that. We have examined the 65 amendment, 51 amendment. Now we go to the 65 amendment.
Yes.
That is the Orange amendment, right?
Yes.
Orange is basically in section 23, the 65 amendment.
Yes. There is no other change, my lord. There are some changes, my lord, in, no, there is none.
I think 23. Just let's see what happens.
23, my lord, the court. The court shall consist of the chancellor, the pro-chancellor, and the vice-chancellor for the time being, and such other persons as may be specified in the statute.
Then subsection 2 is deleted.
Is deleted. The court shall be supreme authority, etc., etc. Please turn the page, my lord, over. And it is given, my lord, advisory function. in accordance with, I'm sorry, ma'am, statutes. The functions of the court shall be to advise the visitor in respect of any matter which may be referred to the court for advice, to advise any other authority of the university in respect of any matter which may be referred to the court for advice, and to perform such other duties and exercise such other powers as may be assigned to it by the visitor or under this act. Lord, this
was 65 amendment.
this was 65.
What happened in 72? Anything substantive in 72 or?
Yes, my lord. Lord, please come to, my lord, section 23 only. Lord, there is no major change, my lord, in other aspects, except, my lord, some powers of the Vice Chancellor are improved. But 23 in 72 Act, the constitution of the court and the term of office of its members shall be such as may be prescribed by the statute. Subject to the provisions of this act, the court shall have the following powers and functions: to review from time to time the broad policies and programs of the university, and to suggest measures for the improvement and development of the university, to consider and pass resolutions on the annual report, annual accounts of the university and audit report thereon, to advise the visitor in respect of any matter which may be referred to it for the advice, and to perform such other functions as may be prescribed in the act.
Sorry. Could the original act 17 and 18 also? 17 and 19.
Yes, ma'am. Please come to 17.
There is some provision in 19.
Chancellors shall be elected by the court.
Yes, ma'am. No change in 51 and 65.
Now,
72, they made that change in
Yes,
bold.
no, the chancellor shall be appointed by the visitor in such manner as may be prescribed by the statutes. The chancellor shall, by virtue of his office, be the head of the university. The chancellor shall, if present, preside at convocations of the university
that's
head.
not relevant. That's not right. But what is relevant perhaps is that prior to in the original enactment, the successor to the chancellor shall be elected by the court.
Court. Now.
And number two, vice chancellor also, the successors to the first vice chancellor shall be elected by the court amongst its members.
Yes, ma'am.
After the amendment, they will be appointed by the visitor.
By the visitor.
But such appointment shall be subject to the approval of Governor General and Council. Vice Chancellor is concerned.
One very interesting amendment which was made in 1972, come back to section 5.
Yes.
See 5(2).
Yes.
University shall have the following power. 5(2) was to promote Oriental and Islamic studies and give instruction in Muslim theology and religion, and to impart moral and physical training.
This was original.
D now comes in.
Yes.
It says to promote the study of religion, civilization and culture of India.
Of India, not one religion.
It becomes more secular in its
More
form.
secular.
Then
And
comes
thereafter-
81. Then comes 81.
Yes, Manoj, please
81
come to
is green,
81.
right?
Manoj.
Green is 81.
Lord, definition clause. Please come to the definition clause. This does not stand as of now, my lord. It's set aside. L, my lord. 2L.
University.
Yes, university means
Just
Aligarh.
Just one.
The lordships have 2L, my lord. Lordship C. L.
Means, yeah.
University means, Lord, originally it was Aligarh Muslim University, the educational institution of their choice, established by the Muslims of India, which originated as the Mohammedan Anglo-Oriental College, Aligarh, and which was subsequently incorporated as the Aligarh Muslim University.
What the amendment of 1981 did was to squarely sort of give it a minority status. That was the object. Because two things they did. They deleted the word established from the preamble, and in the definition of university, they now take it, it's a recognition that, well, this was established by the Muslims of India.
That can be done or cannot be done is a subject.
No, that's a separate issue.
That's a separate. That's what they did.
What
Yes.
was the purport of the amendment?
Yes, that's what they did.
Freedom C.
So, let's start.
It's well settled that the legislature, whether it's a state legislature or parliament, can take away the basis of an act of the basis of a judgment. So, for instance, if a judgment holds a statutory provision to be violative of Article 14 on the ground that it does not comport with natural justice, the legislature can introduce a provision for natural justice so as to make it in conformity with the law by supplanting the deficiency which was noticed by the judgment. But what you can't do is to directly override a judgment, right? So, for instance, the classical case was Madan Mohan Pathak, where there was a binding settlement, an industrial settlement, on which a mandamus was issued by the Supreme Court. That settlement was sought to be overridden by an amending provision, which the court held this you can't do because it has attained finality. Now, what does 2L do? 2L, or before we go to 2L, what did Basha do? Basha said that AMU was not established by a Muslim minority, but was established under an act of the imperial legislature, right? And it is administered not by the minority, but is administered by this institution, by the act. Can by merely an amendment to the definition, can you take away the basis of Basha? Because
My legal
2L does possibly what the argument, and this we may have to hear the other side in response because this was not argued in the opening, that 2L merely alters the definition of the expression university. But does the alteration of the definition of the expression university take away the basis of Basha? That the very establishment, now what the 81 amendment does is, it doesn't purport to establish the university at all. Now, it says that the word establish is taken away from the preamble.
But incorporated remains.
Incorporated remains. Then 2L says that it was established by the by the Indian Muslims of India, originating as the MAO College Aligarh,
Correct.
and which was subsequently incorporated.
The argument rejected is in Bhasha is incorporated by way of a definition.
Now, is this amendment, by the way, in 81, is it retrospective or is it prospective?
Lord,
Lord, our argument before the Allahabad High Court is it's declaratory in nature and therefore retrospective.
Necessarily retrospective.
That was the argument.
Lord, I don't wish to give examples, but if you can change history by changing definition in a statute, your lordships can, with your lordships' wide experience and wisdom, visualize, Lord, what can be done. There are several historical facts, my lord.
No, Parliament
which
can do it.
May, my lord,
But
Parliament think of
Parliament
change.
has the power to do it. Parliament has the power to do it. Because Parliament can, while implementing a statute, subject to a challenge under Article 14, Parliament can.
Competence, yes.
It has the competence to say this
But
is our
whether
view
it
when we enact
amounts
the law.
to effacing
certain-
Bhasha or not, that's a question.
That the more important substantive point is this really declaratory as they are arguing? Or are you merely amending the definition without taking away the basis of Bhasha? The latter you cannot do. The former you can do.
You can't sit in appeal. The Parliament cannot sit in appeal and set aside the judgment. It can, if there is some lacuna found by the court, that lacuna can be filled up. But, Lord, it is my submission and
So Bhasha said that AMU was not established. Bhasha says AMU was not established by the Muslim minority,
intra-party dispute
but
is
it was established under an act of the imperial legislature. Does this, can merely an amendment to the definition of the expression university take away that basis of Bhasha?
And, my lord, their argument that it was established by the educational institution of their, by Muslims of India, which originated
Because
at
to take away the basis of Bhasha, you have to take away the underlying facts on the basis of which Bhasha has been decided. Have they really altered those underlying facts by this amendment?
I requested your lordships that I would like to read Bhasha the way I request your lordships to read. Bhasha doesn't say what they are apprehending. Bhasha is a sui generis Allahabad, Aligarh University case. And it defines and records certain factual findings also, which, my lord, this amendment of the Parliament seeks to do away with.
Is there an alternate reading not possible? I mean, we are just discussing various options. I mean, we just because the idea, it's not an easy, it's a thorny issue. The original act said the university is established and incorporated under this act. The preamble says established and incorporated. Right? Suppose established was not there and it had merely used the word and incorporated under this act.
Only incorporated.
In which case, it would have been established by whoever it had been established by, but it was given a statutory form of a juristic personality by the original Act of 1920. Now, Bhasha relied heavily on the preambulary provision, which says established and incorporate. That is, means you are setting it up for the first time by the Act of Parliament.
Even incorporation would
Is
be
it not
setting
open-
it up for the
right.
first time.
No, that may be a little different because incorporation is giving it a juristic form. Establishment is an establishment, in fact. But is it not? Is it open to Parliament? Is it, or put it the other way? Is it not open to Parliament to say that, well, Bhasha relied on a statutory provision, namely the word established, to hold that it was established under an act and not by somebody divorced the statute. We will amend the statute to take away the word established, so as to make it clear that our intent is that this was only given a juristic form by the Act of Parliament.
Can the
Can Parliament
intention
not
of
do that? Can Parliament not do that?
Lord, can the intention of the Parliament as it existed in 20 be supplemented or amended that this was the intention?
That you
after
can always do. That you can. There's no. Parliament's power is untrammeled.
Let that be argued. Lord, they were not comfortable in arguing this point. They said, let it go to the regular bench. I am ready to argue. This is set aside by the division bench of a High Court by a
Parliament does
reasoned
that
order,
all-
I'm ready to
Parliament
support.
does that all the time in the case of fiscal enactments. You'll have amendments by the galore in the Income Tax Act. The moment a judgment comes, they will amend it with retrospective effect.
My lord, this, my lord, there are, we have, my lord, judgments on.
These are what we call a validating statute or
My lord, we have judgments, my lord, whether this can be done or cannot be done, and to support the judgment of the division bench of the High Court, and we have filed an
But
affidavit.
then one thing, let's have conceptual clarity on what we are going to write on. I mean, what is the canvas on which we are going to write? If they are not arguing on the
They are not
validity-
ready to argue.
No,
We
ready to
want
argue.
them to argue.
They are not arguing. That's their choice. One second.
We shouldn't argue the 81 Act.
No, they said that let it go to the regular bench.
Just one
They
second.
say.
One second. We've got our notes. In the opening, they have said that they are not arguing on the validity of the 81 amendment, which forms the subject matter of the Allahabad judgment. So, for the purpose of this reference, then, do we proceed on the basis that the 81 amendment is a valid amendment?
It cannot be.
Oh, sorry,
This-
the 18 or 81, the other way around. Amendment is now effaced from the statute.
Yes, my lord, it's not, it does not exist on the.
By this court.
Ah.
Mullahs,
It's not stayed, it's not stayed. The court said status quo because they have granted reservation.
one second.
That was the state, therefore say that the
Where
status quo.
reservation, it is not state, otherwise it's status quo ante.
No, no, I'll show the
The
order.
order of the court. It's there. It is status quo ante,
No, no, you have-
other than the issue.
You can't have it both.
If- if-
Let us be very clear.
If I remember correctly, what it transpired was, we were, that in case it's a minority institution, then the corrector will be issued in terms of the constitution and the rights protected under Article 30. So we're going on that basis.
All,
But to be fair to the solicitor, the argument of, which has been raised is that in Badshah, the court found three things. One, it was legally established. Two, in fact, de facto also, it was established not by the state. It was established by the state and not by the minority institution. And third, it is not administered by the minority. These are
And
three.
four, you have whatever rights you had, you have surrendered those rights.
So that is
That's a factual
part
finding.
of, that's part of the second, that it was not established and administered. It's a part of second and third itself, because you surrendered.
So
those.
that factual
So-
finding that you have surrendered,
So your argument is, even by adding even by deleting the word established from the statutory enactment, it will not unwind or rewrite the judgment of the
Aziz Basha.
Badshah's case, that it was de facto established by the state.
Mr. One more thing, Mr. Solicitor, I'll have a word with my learned colleagues over the lunch break. I'm just throwing this as an idea. It's not even my confirmed opinion. So it's just for the sake of a debate or dialogue in the court. You will also concede, and the other side will also concede, that the 81 amendment does have some bearing on the minority character of AMU. What bearing it has, it is for your argument, their argument, and we'll decide it. If we accept that the 81 amendment does have a bearing on, some bearing on the minority character of AMU, because let's face it, the object of the 81 amendment was to reaffirm the minority character. That's the whole purpose of 2L and that preambulary change. Now, if the 81 amendment has some bearing on the status of AMU as a minority or otherwise, then can we really decide this without going into the validity of the 81 amendment? Otherwise,
that's precisely we
may,
requested.
because otherwise we'll be making.
No, that's precisely we
Because
requested.
our-
They were not comfortable.
because
They said
Mr.
go to the regular
Solicitor,
bench.
because look at it this way, Mr. Sibal, please look at it this way. We are a bench of 7. Can our judgment be made contingent on what a bench of a lesser constitution will decide on the validity of this amendment? If this, take it against you for a moment, just for the sake of argument. Suppose we reverse the judgment of the Allahabad High Court. And this is only for the purpose of testing the hypothesis.
Yes, yes.
Not at all.
I-
Our mind is completely open on the 81, but I'm just putting it against you because suppose we reverse the Allahabad High Court and affirm the validity of the 81 amendment, right? In which case, the consequence of the amendment of 81 is to clearly confer it or recognize it, as they say, the minority status, whether it is declaratory or confirmatory.
Maybe subject to certain arguments
Yes,
which we may
that
make.
arguments are on both sides are open. In which case, how can we say that, well, we will decide this minority status of AMU dehosts the 81 amendment? And the moment you look at the 81 amendment, we have to necessarily look at the Allahabad judgment. So perhaps, I mean, we will all sit down at lunch
We
maybe for
have
5
been
minutes.
saying that right through.
At lunch, we will all have a confabulation between us because I have not had the benefit of my
Kindly
learning.
not recall,
My
Lord,
colleagues'
it was
views.
our case that your lordship will
So,
have to go into the merits. They said, no, this question may be decided
So,
by
if
regular.
Mr. Solicitor, you can continue with the rest of your arguments. But if we come to the conclusion that we will have to decide the validity of the Allahabad judgment here, then you can deal with the validity of that judgment in your
No, Lord,
argument.
first
now.
let them argue it. Lord, at that stage, Mr. Dhawan got up and said that I'll
You
take
can
2
argue,
days.
you can support the judgment and we will hear them in response. That will be much faster. Otherwise, then we'll have to again go back to Mr. Singh to argue.
Let them have, my Lord, the.
My specific submission in the written submissions is that the 81 amendment is valid. Specifically there.
Obviously,
But
that's
once
that
the
way.
lordship said, let it be decided by the other bench, then I didn't complete the argument.
No, my
No, I
Lord.
thought,
Getting away from it.
No, he
Doctor,
said that.
my recollection is that
Not
you
fair.
said, I am not going into that, let it go into the.
Yes, and let it be done by the regular bench. That was Mr. Dhawan's submission.
If I remember correctly.
On our side, we were saying that you will have to decide it.
We are not hesitant to,
from this
we're
side.
not hesitant, but if I remember correctly, I had said, if you,
In
Maharaj,
on something.
हमारी सबमिशन कहाँ?
The consequence of the interim order is that AMU said we will not implement the 50% reservation. But the status quo, as on the date of the filing of the writ petition, was to be maintained. That is to say, when the petition was filed, Brother Dipankar Datta says 2004, the 81 amendment had already been brought into force. Therefore, the 81 amendment today, as a result of the interim order of our court, is operative.
that's right.
But the question is, my Lord, without going into the validity of that judgment,
Uh-huh.
it would not be possible for your lordships, my Lord, in this.
Prima facie, you may be right on that. Mr. Sibal, just reflect on it at
No,
last.
we'll reflect, but what I said,
Stay of judgment.
1 second.
That's not stay of judgment.
Judgment, my
No,
Lord.
Neeraj, look at the latter part. The latter part, that the status quo will be maintained as on the date of the filing of the writ petition.
That is
And
for
if you-
reservation.
That's for reservation, and also, my lords, the next line, since your lordship said should be considered the 81 issue. The next line says it's desirable
For the
that a larger bench
Then
considers
stay
the
of the
judgment
judgment.
also. Because your lordship
May-
put
may-
a
There
question.
is no stay of the Allahabad judgment.
Operation
per
of the
se.
judgment has not
There
been.
is none. There
There's
is
no
no.
stay of the Allahabad judgment.
May I say something, bro? May I say?
What is-
No, may I give a little background?
Yes, it's status quo, Maharaj, for all other matters.
That is only reservation. Put the question that should your lordship
Well,
get into the 81 issue,
If your lordship,
81 amendment, the same order says that it is desirable that this matter should be considered by a larger bench, and your lordship that today seized of the matter. The same order. In the
So
next
what
case
has
says
happened,
It's
Malak?
desirable.
What has happened, and I'm going to
These are
make
of
this
general
submission
importance,
good.
which is there, that matter we can.
The matter is referred, not the question. That's the,
I
that was
remember.
our case.
if I remember correctly, Maharaj, I had argued,
Don't argue and then.
if you set aside Basha. then
No, there is no setting aside. This is not an appeal.
If you do not agree with Basha, then 81 amendment doesn't arise. That's what I had said. If you do not agree with Basha, then the 81 amendment need not be gone into. It's so, if what my Lord the Chief Justice said is right. If you say that Basha was right, Malaz, then the question of 81 amendment comes in. But if Basha was wrong, 81 amendment need not be discussed.
For deciding whether it is right or wrong,
Allow me, sir, to conclude.
81 will have to be examined.
I am not saying no, I'm just, please allow me. So if your Lordship's Malaz on our argument says that Basha is wrongly decided, you don't have to go to the 81 amendment. So decide that question, Malaz. What's the problem with that?
Point, Mr. What you are saying, look, Parliament amended the Act in 1981 to really, should we say in a colloquial sense, to override Basha.
That's right.
Right? Now, what you are arguing is that if you come to the conclusion that Basha was wrong,
Yes.
then there was no question.
Yes.
But even so, if we come to the conclusion that that Basha was wrong, we'll have to still, we'll have to still deal with the validity of the 81 Act.
No, but then, Malaz, it goes without saying whether it is trying to override the judgment or not. It is established by the minority, recognized under the...
But suppose the Lordship decides that Basha is right, then what?
Don't allow. That question will not arise.
What happens then if we decide that Basha is right?
If the Basha is right, Malaz, then the 81 issue will have to be gone into.
Only
Then by the regular bench, that's their,
then only.
That is,
Problem is
that's
just
the only issue that is referred to your Lordships, Malaz.
Just now you
Whether
said
Basha
that
is right or
1981 amendment survived.
Yes.
Problem is that just now you were saying that 1981 amendment is still operative.
If
If
your Lordship
your
agree
argument
with
is that
Basha,
it is still operative, then we have to go into
your
the
Lordship
validity from
agrees
that.
with Basha, Malaz. If your Lordship agrees with Basha, then of course the 81 amendment is there. If you disagree, yeah. No, don't look at it today, Malaz. Just look at Basha, is it right or wrong? And if your Lordship says the Basha is wrong, 81 doesn't matter.
what if the court says Basha is
That
right?
becomes an academic issue. Why? Because it is established by the minority and under 31 Malaz is recognized.
If we say that Basha is wrong,
Yeah.
then according to you, then the amendment in that sense recognizes what we feel also is the correct position.
Then, Malaz,
So what if we come to the conclusion that Basha is right?
then you have to go into the 81 Malaz.
But then if we say that Basha is right, then who goes into the 81 amendment?
Malaz, that it is not referred to 7 judges. The 3 judges who would hear it will go into it.
This is the problem.
No, it's not a problem. That's the process. That's the reference is only que Basha. The reference is not que the 81 amendment. I don't think that we should that we should go into that.
Keep having a bite. Conveniently, keep having a bite again.
On this at lunch, in deciding, your argument is that if you come to the conclusion that Basha is wrong, then the 81 amendment really becomes redundant. But just reflect on this. Can we decide on whether or not Basha is correct without looking at the statute as a composite whole, including the 81 amendment? Okay, technically today, true, as the solicitor said, 81 amendment is now not on the statute book because it has been set aside by the Allahabad High Court. but everything is live before our court.
No, Mullah,
Now, may not be live before the 7 judges, but it's live before the Supreme Court. Therefore, in deciding whether Basha is right or wrong, Basha itself has interpreted the provisions of the statute while coming to a conclusion, right? It relies on all the provisions of the statute.
that's correct.
Now, can we, while deciding on the correctness of Basha, say that we will look at only some of the provisions of the statute, but we look at the statute minus the 81 amendment?
Well,
That
then
may be very artificial for us.
The loss is the
isn't it? I don't-
problem.
I
I'll tell you, loss is the
just look
problem
at it
that will
way.
arise. If I may, I'm sorry. Then, Mullah, then your logic, just give me a few minutes, Mullah. Either we look at Basha and on the basis of what happened in 1920. That is, look at Basha through the lens of 1920. Or we look at Basha in the context of Article 31 when it came into force in 1950 and what happened thereafter. His argument throughout has been, don't look at anything else, look at what happened in 1920. That's been his argument throughout. But please, if you don't want to look at Basha in the context of 20, please then look at this in the context when the Constitution came into force. Then apply all the principles of constitutional law in Article 30 to look at Basha. Then you'll have to do that also. And then 1981. That's not an easy exercise.
Lord Basha also, Lord examines
Therefore,
51
that question
and
will arise.
65th amendment.
Therefore, you'll have to look at Article 30, sub-Article 1.
And
You
two-
don't look at
two
Basha
amendments.
on the lens of 1920 then. Then you'll have to do into all that. And my respectful submission is, Mullah, that exercise need not be done. We are ready to, Mullah, to argue Basha in 1920, because that's how it happened. And that's throughout what has been said. Look at the Constitution, look at the regulations, look at what Basha says, look at what the rector said, look at what the chancellors have appointed. This is all Basha 1920. We'll answer that.
Basha, on the basis of the position as it stood in 1968.
Yes. Look at it and see whether it was established by a minority or not.
There is
It's all you have to look at.
There is one more aspect, my lord.
Let me just finish.
Supposing, my lord, your lordship considers 1981 Act also, and your lordship holds that that act is valid. It's unnecessary to examine
You
Basha.
are right, Mr. Deveri, but it's equally valid in case we hold that
I'm
Basha
just
is.
saying consider together, not
So,
by.
so the 81 Act, if it is valid, then Basha in any case is overridden then according to us, because, I mean, that's the argument on.
Even if Basha remains valid, the new act has come which is valid and therefore.
Lord, what they want to do, let me put it in order, let us learn what they want to do.
Basha relies upon 1951 and 1965
Amendment
amendment.
also, yes.
A part of the 1965 amendment has been done away with the 1981 amendment.
1981.
Unless you go into that whether it was done validly or not.
Impossible to separate this.
Not looking at Basha in the context
That's
of
what we were saying
51
from
or
the beginning.
65.
Truncating.
You're not looking at Basha in the context of 51 or 65.
On one basis. This issue had come up earlier and we discussed, and thereafter we proceeded on this basis. We are examining the validity of the ratio in Basha.
That's all.
Number one. Number two, the reason was, why we said so was, we have to see the status of AMU as on the date when Constitution was enforced. In case we come to the conclusion, just 1 minute, please. In Badshah, when we read, we found there were 2 aspects dealt with specifically in Badshah, or rather 3 aspects which were specifically dealt with in Badshah. One is, what is the effect of statutory enactment of a university, of creating a university? Badshah says, this is the enactment which establishes the university. This is the only aspect dealt with in 1981 amendment. The second aspect dealt with in Badshah. Now we can hold, this bench can hold, yes, the statute established the university and therefore AMU came into existence. In which case we uphold that, then 1981 amendment has to be examined. And that can be examined by a separate bench, because then the limited issue is what is the consequence of that amendment? Number one, there the argument which will arise is, could the legislature, by merely deleting the word establishment, override the judgment of this court? That will be the issue, which is a separate issue. We have not addressed, nobody has addressed us. We have already gone through by about 5 days or 4 days. Nobody's addressed us on this. The second aspect which is dealt with in Badshah relates to administration. And it says it is not administered by the minority right from 1920 or as of in 1950. That's the most important legal issue, because both the sides concede that both the things have to be, in order to be a minority institution, it should be established as well as and administered. So that's a legal issue. The third point raised is the amendment made in 1981. The Badshah holds it's not established, de facto established by the minority, and that issue is again before us. So really speaking, we need not go into 1981 amendment per se to decide whether Badshah is rightly decided or wrongly decided.
Mr. Solicitor, Mr. Dwivedi, just 1 second. What we'll suggest is this. You are in the midst of your argument, replying to them on merits.
Yes.
You can conclude your argument. Anyway, even if we decide to go into the validity of the Allahabad judgment, you said they should open first. We understand why you're saying that, no difficulty. So on this aspect, you complete your submissions. When we read Badshah with you, again, we will be able to then fine-tune our own understanding on whether that issue of the Allahabad judgment should or should not be decided together. We will read Badshah with you. So when you are reading Badshah with us, or for us, you can also focus on these issues which Mr. Dwivedi, Mr. Kaul and you are saying requires us to also decide the issue of Allahabad in this reference. So right now we can continue with your submission, because you're now on the almost at the latter fag end of your at the end of your submissions.
That's not the.
So we'll conclude your submission.
Really this.
It's the appropriateness.
Yeah, appropriateness. We will hear you at the end once you have argued on Badshah.
Only give me
We will hear you for 5 minutes on that, and then we will hear the others anyway, because this has to be dealt with. The merits everybody will argue. Then on the appropriateness of considering the issue of Allahabad as well, we will hear each of you and then take a call.
I'll just add one thing. I bow down.
That's fine.
What has happened is this.
As far as the 51 amendment is concerned, Badshah says it was just in conformity with the Constitution. We have argued that the 65 amendment was an emergency amendment, but it was reversed in 81. To that extent, my lord, we can certainly go into it depending on what
It's not separable. On this argument, it's not separable.
Now, you have shown us this. We have anything else that we need to see in the chart, so that then after lunch we can.
The chart, my lord, is.
Now,
What is happening?
What is the remaining part that now?
What is happening is this. And let me, my lord, be a little more clearer rather than being diplomatic. What they want is, they are taking a chance whether Badshah is right or not. If your lordships are satisfied that Badshah is right, they will have a second round to say that even if 7 judges said Badshah is right, now have a second round that now the basis is taken away and refer this question.
No, if Badshah is right, no.
But that may not happen. In case we uphold Badshah or agree with the ratio in Badshah on the second and third aspect, they may not have any say in it.
My lord,
On the second and third aspect, that is de facto, it was established by.
No, I think what perhaps solicitor is arguing is that if we come to the conclusion that Badshah is right, then the issue of the validity of the 81 amendment will be before a lesser bench, a lesser constitution.
That's what we want, a second round, my lord.
The argument there could be that, look, the basis of Badshah is taken away by the
Therefore, no
1981.
need to go into this. That's all, that's all that there will be.
That's exactly what is the problem.
But there will be
That's exactly this.
There is no problem. You don't have to.
You
go
can't
into it.
have, my lord, this kind of
When
second bite at the
seven
cherry.
judges say Badshah is wrong, what else?
We
is
can't
left
deal
in the
with
matter?
7 judge bench like this, my lord, that you decide what is comfortable to me and don't
I
decide
think you are
what.
more hurt about it than the 7 judges.
Both should be decided together. That's the appropriate.
Lord, the reference is the matters are referred.
On this, we'll just defer it a little bit. You conclude your arguments. We'll also read Badshah with you. Once we reread Badshah with you, we would have read Badshah with two different perspectives.
I need to read, my lord, some debates in 65 and that would be very crucial.
All right, so now after this, you'll be referring to the debates
Yes.
and then directly take us to Basha, or what's the?
Yes, that's the.
And then we'll conclude.
There is only one thing I must.
So I guess about 20 minutes for the debates
No,
and about half
I'll
an hour for.
take 7 sessions. I'll not repeat anything.
No
Not
difficulty.
repeat anything.
So, but now what remains from your argument is the debates and then followed by Basha.
Basha and a few other points.
But there is only one thing I must point out, the legal obstacle for them is the court suggested by them. If Lord Basha is to be considered independent, not in the right of 81. Virtually these proceedings will be sitting Lord like an appellate proceeding.
That is going to be my submission.
On principle, Lord, larger bench can go into the ratio, not the decision in that case. That's what.
Not the factual findings. That is going to be my submission.
To convert the reference Lord into an appeal.
It's not an appeal from 5-judge bench to 7-judge bench, intra-court appeal. The argument was, look at this, what he says, look at this, what he says.
In fact, Manoj, that's going to be one of my
Presently,
functions.
look, we'll presently be open unless,
There are
until
some
we read
judgments which
Basha.
I'll be citing.
Until we read Basha with the Solicitor General, let's, because, ultimately a judgment also depends on how it's, how it is interpreted by both the sides. So let's read Basha with you and then we'll take a final call.
And
Just
there are
one more
some
anomaly, my
judgments
lords,
followed on.
reflect on that, my lord. Just one more anomaly. Assume, my lords, my lords decide that Basha has rightly decided. By relegating the 81 question to a smaller bench, they will get the opportunity to argue that notwithstanding Basha, 81 amendment is declaratory and curative. Therefore, Basha will not apply. Please see the anomaly. Then 7 judges will now held Basha, and thereafter
have choice of 2 litigations, my lord, in a matter which are inseparable.
And again, anomalously, my lord, they'll argue what is something contrary to what is decided.
We'll not conclude an opinion at this stage. Let's, because solicitor is on his legs now, and we have almost substantially completed the arguments. One more session is what he requires. So today we'll finish anyway, even by his own